No.
Not yet.
I found out where Lost and Found is.
Oh.
I didn't lose something, but I found it.
Okay, I didn't know we had lost and found.
We do it down in the coat room where the village council used to be on the first floor down there. There's a box that said Lost and Found.
I wonder if my sunglasses that the governor's.
Probably is.
Are there.
Yeah, and there's some things over there that I think we can take down to Lost and Found.
Oh, I should take my jacket.
There's an umbrella there, it's been there for 2 years, and a coat that's been there for 2 years. I'd say they're lost and found.
Perhaps.
Anyhow, good morning. This is Friday, January 19th, 2024. We are taking up for a number of bills this morning, including S209, an act relating to prohibited unserialized firearms and unserialized firearm frames and receivers, and juvenile offenses in the criminal division. And we are taking up the confirmation of superior judges. And later on, S58, an act relating to increasing the penalties for subsequent offenses for trafficking and dispensing or sale of a regulated drug with death result. And first witness this morning is the president of the Vermont Federation of Sportsmen's Clubs, Chris Bradley, who's here probably to talk about S209 and the sections having to do with prohibiting unserialized firearms and unserialized firearm frames and receivers. But if you'd like to speak to the juvenile offenses, we're happy to hear that as well.
Thank you, Chair Sears. For the record, again, my name is Chris Bradley. I'm the President and Executive Director of the Vermont Federation of Sportsmen's Clubs. I'd like to jump right in. I know we have limited time. It's only half an hour.
Yep.
The intersection of unserialized firearms and felony crime only occurs when unserialized firearms are used in felony crime. Reducing this bill to just that offense accomplishes what we believe is the central goal of this bill: to reduce and hopefully eliminate the use of unserialized firearms in felony crime by creating stiffer guidelines for punishment, doing so in a manner that does not create unenforceable laws that would significantly impact and hurt law-abiding citizens through the loss of time and money. I begin by making clear that the Federation can support the creation of a statute that would make it an offense to use an unserialized firearm in the commission of a felony crime. And we additionally feel that this should be an offense with a required minimum sentence in addition to a possible maximum. The Federation has significant concerns, however, regarding the attempts to regulate the making of a firearm by a private citizen for their own lawful use, as well as penalizing the possession of an unserialized, unfinished or finished receiver legally owned by private citizens. Under federal law, and reiterated in the ATF Final Rule 2021, which clarified several issues concerning the Gun Control Act of 1968, an individual citizen can legally make their own firearm. That's called a privately made firearm, PMF. And per ATF and federal law, a privately manufactured firearm does not require a serial number while possessed by its owner. Per the ATF, a PMF is defined as, quote, a firearm including a frame or receiver completed, assembled, or otherwise produced by a person other than a licensed manufacturer and without a serial number placed by a licensed manufacturer at the time the firearm was produced. A historic problematic issue for the ATF has been to precisely define what part of a firearm is the part that should be serialized for commercial purposes, with that part being referred to as the firearm's frame or receiver. Since the Gun Control Act of 1968, federal law requires that all commercially manufactured firearms have a serial number, with a serial number stamped into the frame or receiver. Prior to 68, however, this was optional. There are older firearms in civilian hands which do not have any serial numbers, and they are all legal to own. Both previously and still today, the ATF has an 80% rule, a rule which gives some guidance on when a piece of metal that is in the process of being machined into becoming a fully operational frame or receiver can be considered an actual firearm. For example, in the case of an AR-15, it is the lower receiver that is designated part that makes it a firearm. Buying a serialized frame receiver is just like buying a functional firearm. You go through an FFL who does a background check to eventually possess it. Setting aside 3D printing, which we believe can be used to print 100% receivers, and whether an aluminum metal receiver is forged or milled, which are just methods of manufacture, I think we can agree a raw block of aluminum is not an AR-15 receiver. As that block of aluminum is machined into an actual receiver and progressively gets more and more completed through a series of machining steps, arguments can be made as to the percentage of completion. If it is 80% or less, it is not a firearm, according to the ATF. In years past, and even today, there are companies that sell firearm kits, with these kits including all the pieces and parts required to build a functional firearm. Most of these companies sold these kits with a serialized frame receiver, and they therefore followed federal law, selling them through the same process that firearms are sold today, through an FFL and only after a background check. However, other companies sold firearm kits that included unserialized receiver frame, and they claimed the 80% rule because it was quite literally a pile of parts requiring assembly. These kits were sometimes referred to as buy, build, shoot kits. The final ATF Rule 2021 R-05F addresses the tactics of these other companies by now requiring that these buy, build, shoot kits be sold as a firearm, requiring a transfer through an FFL and a background check. Just as an aside, the new ATF rule allows a person legally owning an unserialized PMF to go to a gunsmith for repair or work, and as long as that work is done in 1 day's time, there is no ATF requirement for the FFL to serialize. By allowing such, the ATF is in fact fully supporting the concept of a law-abiding citizen having an unserialized firearm. However, neither this new rule nor any existing rule prohibits a PMF or privately made firearm. We are certain that there are hundreds, if not thousands, of Vermonters who own firearms they built themselves that are unserialized. We are certain that there are hundreds, if not thousands, of Vermonters who have purchased 80% receivers. They cost about $50, with that non-firearm sitting on a shelf or in a box with a thought that it may be someday a future project. We are certain that there are perhaps hundreds, if not thousands, of Vermonters who had an 80% frame or receiver that is now in some state of completion. All of these Vermonters will be legally and monetarily negatively affected when this law goes into effect on December 31st, 2024, a little over 11 months away, assuming they even become aware of it or realize that it affects them. For those people, we see problems with the phrase temporary possession, because these 80% receivers have been available for years and years without any concern whatsoever over their legal ownership, because they are technically not a firearm. Furthermore, firearms made from 80% receivers that have been finished or are in some state of being finished are not a legal concern either. Stepping back for a moment, it is not a trivial exercise to build a firearm, even from a buy, build, shoot kit or a 3D printed 100% receiver and the required parts. To turn either into a finished firearm requires the use of tools such as a bench vise, receiver vise, barrel wrench, and other tools, and some expertise with those tools. In considering the desire for stamping a receiver frame with a serial number, it must be recognized that most FFLs in this state are not set up to perform this stamping work, as they predominantly only sell firearms. As an aside, I believe there's about 330 FFLs registered with the ATF in Vermont. Approximately only 80 of them have a Type 7 license, which is a gunsmithing license. So not all FFLs can handle this. Stamping a firearm is usually done by a gunsmith, with good gunsmiths typically having a significant backlog of firearms to work on. They will also charge money. This will likely be a lengthy turnaround. Once they finish their work, a background check would be required, and there is concern that under the new FFL rule, FFLs can refuse to handle an unserialized firearm if they so choose. Temporary possession will be hard to prove because there are no serial numbers to trace the date with which they were originally created, and all bets are off when you consider 100% receiver can be printed on a 3D printer, which would cost possibly $500 or less. How would we ever control something that can be printed? In crafting this law, we do understand that nothing in S209 prevents a person from building their own firearm, a concept that would likely be challenged, and is in fact being challenged elsewhere in states such as California and Colorado, and I understand that this bill was based on a hybrid of Colorado-Washington. In the final analysis, the net that will be cast to force serialization will only impact otherwise law-abiding citizens who have to find the time and money to find a skilled gunsmith to perform the required serial number stamping work, and then forego having that firearm for what could be a lengthy amount of time for the gunsmith to perform the work required. Some will adhere, but I suggest that some will not, either through conscious resistance or simple ignorance. How would we ever find them? By going door to door? In working through the bill, we set aside definitions found in the section 4801, other than to say that the definition found in 8, which is an unfinished frame receiver, uses the phrase, quote, when it may readily be completed, assembled, or converted, end quote, which is vague, with our public safety officials being challenged to make this assessment. Concerning section 4802, that would be A1 page 4, lines 3 through 6. Given that federal law allows a citizen to make their own firearm, it should not be illegal in Vermont to possess, transfer, or offer to transfer something that is not technically a firearm. On section A2A, page 4, lines 8 to 9, this is not needed because FFLs will follow the law. And something you should know about the new FFL ATF guidelines. As I said, a FFL does not have to take a PMF into inventory. If they do, by federal law, they are required to stamp it according to the ATF standards. So ATF already authorizes FFLs to stamp, and by federal law, they have to stamp if they take that into their inventory. So we see a bit of redundancy here, but let me continue. A2B, page 4, lines 10 to 12, in considering the phrase temporary possession, and as noted above, there are potentially thousands of Vermonters who legally purchased unfinished receivers and firearms with the thought that someday they might make a firearm. Use of that phrase casts a wide net that will ensnare Vermonters who may engage in a lawful activity per federal law. And per federal law, a PMF does not need a serial number. In summary, we can't support that section. Section B1, page 4, lines 13 to 16. Per federal law, it is legal for a citizen to possess a receiver frame that is not imprinted with a serial number, that's a PMF, so we feel the term possess should be removed. As far as transferring a PMF, you can do this. And obviously, 4019, the background check allows firearms to transfer, say, within family and inheritance. You can transfer through from an unserialized firearm to another law-abiding citizen because you go through an FFL. That FFL is going to stamp that. And by the way, we have a background check 4019 that now requires that we have to go through FFLs. So that process will end up with a stamp. That stamp then gets entered into the FFL's book. which records the transfer and who purchased it. And we've now complied completely with federal law. So it should be, as far as transferring, per 13 VSA 4019, firearm transfers background checks, all firearm transfers must go through an FFL for a background check. And per federal law, that FFL must stamp that receiver. As far as, quote, offer to transfer, the person offering to transfer will legally eventually have to go through an FFL, and we're in the same path again. So I may sell, Eric, would you like to buy this? If you say yes, then we still have to go through an FFL and get it stamped. So I can offer it, and I'm not sure that that's necessarily illegal at all. B2A, page 4, lines 19 and 19. Again, I'm not sure you need to tread into the world of ATF. FFLs are under very strict federal guidelines on how they're going to handle this. B2B, that would be page 5, lines 1 to 3. Per federal law, it is legal for a private citizen to manufacture a PMF that is unserialized. If made with a 3D printer, which would still be legal, the ATF does not recognize serial numbers engraved into polymers or plastics. And that's because it's too easily to deface that. So even if you do a 3D printer, to have a legitimate legal receiver at the end of it, it has to be, it has to have a non-removable plate attached to it. So it is not trivial, and it should be a significant amount of time. So in summary, I'm afraid we can't support that section. Section C, page 5, lines 7 to 10. In considering this offense, we must reiterate that per federal law, it is completely legal to build and manufacture an unserialized firearm. While there is concern that an unserialized firearm cannot be returned to the law-abiding citizen that owned and made it unless it's serialized, by and large, gun owners take care of their firearms, and we just passed a safe storage law to help remind gun owners to take care of how they are stored. Should an owner of an unserialized firearm ever decide to transfer it, then while it can be done in some cases without a background check, again, immediate family members, it will have to go through an FFL, and again, that'll have to be serialized. Page 5, C2, lines 11 to 12. Again, we're dealing with FFLs that are tightly regulated by federal law. I'm not sure we need to have that. So unfortunately, I have to say that we have trouble with that section. D1, A, C, all of the offenses related to the previous 3 sections, I'm not sure we can support because we're challenging the premise of it. I come to D2, however, and we have significant agreement with what this bill intends to do with D2. We can support the creation, as I said, of a statute that will severely penalize someone who is caught with an unserialized firearm in the commission of a felony crime. I think that is what your sheriff would want. And in fact, as we think about this, one of the things that I'm trying to get, I think, law enforcement wise, if you were to find some miscreant with one of these things and he's committing a felony crime, and it's clear that he didn't make it, I'd like to have a lever, me personally, to have a lever that you can apply to that person to say, okay, where did it come from? So perhaps we establish minimum sentencing, that if you do this, you have to do arbitrarily at least 2 years, minimum. Perhaps a minimum fine, and of course there would be maximums. And maybe we want to even have some language that would say perhaps this offense may be reduced if the source of the firearm could be determined. As I envision this, you would have 3 exemptions to this. And they're the 3 exemptions you already have. Non-operable, antique, pre-68. This is something we can get behind. And I think this directly addresses the need.
Hold on just a second.
Yes, sir.
Are you finished?
I had just a little bit more.
Yeah, why don't you finish?
Yes, very good. 4083 per existing, that's the authority to give FFLs the authority to stamp unneeded. That's already in federal law, and that's now regimented by federal law. Section 5204, Senator Sears, we were behind that last year. More power to you. This is a serious problem. We support, even though that's out of our wheelhouse, we support that. Overall summary, to better comport to Bruin and not infringe on the Second Amendment, we strongly suggest that the language of this bill be changed to only address the creation of a new felony crime that would punish anyone who uses an unserialized firearm in the commission of a felony crime, with language that states that there shall be both a minimum sentence and a maximum on top of any charges for the felony crime itself. The intersection of unserialized firearms and felony crime only occurs when unserialized firearms are used in felony crime. Reducing this bill to just that offense accomplishes what we believe is the central goal of this bill, to reduce and hopefully eliminate the use of unserialized firearms in felony crime by creating guidelines for punishment, doing so in a manner that does not create unenforceable laws that would significantly impact and hurt law-abiding citizens. If you would, I don't want to interrupt, I just wanted to share these two things. The committee, if you so kind, just to pass that around. Yeah. The first is just I submitted, that would be for, just as far as the picture pages go, if you, on the top, you see a finished 100% receiver that I purchased with a background check. And just as an aside, that top piece of black metal, I could not bring into the State House because it's against State House rules, because technically that piece of metal is a firearm. Anyway, on the bottom you see an 80% receiver. And I made some notations. There's some holes you can see on page 1 and 2 that are missing. On the page 3, it shows that there's a cut into the bottom that isn't there. Page 4 is really where you need to look. And the reason I think this is important, because this represents what Vermonters, I believe, are going to get caught with or have a problem with. Metal, and you can see that top picture here, that is not trivial. This is not a couple of hours to just remove metal in a precise manner. So I am done, Senator Sears. I'm ready for questions or however I might give assistance.
I just, there may be some questions. I would just comment. We'll certainly look at the 80% rule and how that impacts and so forth. And I appreciate your testimony. I realize that some things are an inconvenience, and we don't want to get innocent people caught up in the criminal justice system by mistake. And so that's one of the things you look out for when you do bills. What I was thinking of is read recently, or it was 22 years ago, that somebody tried to get on an airplane with explosives in their sneakers. And I've been taking my sneakers off every time I want to get into a plane, and it's inconvenient. Then you have to go find a seat to sit down on and put your sneakers back on. It's damned inconvenient, and we're doing that because some idiot tried to bring an explosive onto a plane. So there's a lot of inconveniences that we go through because some idiots commit crimes and do. That's it. Excuse my language. That's all we're trying to get at. And so I appreciate your testimony, and it's how do we get at that behavior. And so I need to understand better the 80% rule and how, maybe Washington and Colorado were developed after or before the rule was finalized by the feds.
Well, I certainly thank you, and I understand. This was a tough topic for us. In your example, everybody suffers from having to take their shoes off. Not the people with pink sneakers, or whatever. There are legitimate law-abiding citizens. It's not everybody's cup of tea to build a gun, and certainly we cannot support crime at all. But it is a legal activity. And I guess just touching base yesterday, there was a comment made that at the time of our founding, they couldn't ever envision the 3D printer, and absolutely, I would agree with that. But at the time of our founding, they couldn't have possibly understood all the advances in communication that we now have, and yet the First Amendment is some fax machines, all of this. So we see a solution, and that's to get really tough when we find one of these things, because other than that, Chris Bradley having an unserialized firearm and you having it for lawful purposes that he built himself is by federal law legal. Mm-hmm. And so that net, would I follow the law? Yes, I would follow the law. And but bearing in mind with only about 80 gunsmiths that are qualified, it's like your favorite car. You don't take it to the meathead mechanic. You take it to the person you trust. And I can honestly say that almost any firearm gunsmith, you have a backlog. I would be concerned that this couldn't be done by December 31st. But
well, we'll get testimony from federally licensed firearms dealer about that part of the bill. Senator Bowski, there's a question.
Yeah, thank you. So you're suggesting an increase in penalty as a means of discouraging crime, and I'm wondering if you can point to any studies that show that an increase in penalty actually has a deterrent effect on crime, because the National Institute of Justice says that increasing the severity of punishment actually does very little to deter crime.
I would be happy to take a look at that. I guess I was looking at it to say, if you were to find, from a law enforcement perspective, as I mentioned earlier, if you were to find one of these situations, somebody coming up from Springfield carrying one of these things, as law enforcement, not only do I want to be immediately prosecuted and harmed, I'd like to know where the gun came from. So if in fact we raise the bar to say, okay, we are going to find out where this came from. I think
but wouldn't a serial number automatically make it so we could find out where it came from?
There's no serial number.
Yes, that's the point.
That's what the bill is trying to ensure, that every gun has a serial number.
I certainly can appreciate that. In certain instances, it's legally owned. I think we're maybe running afoul between what the current federal laws are, and I'm not sure the state wants to be in the position of what's an 80%, what isn't an 80%. Gee, I just saw you with an unserialized firearm, but I know you can legally own it. How will we ever find it unless we're going to door to door, or unless it's used in crime?
Mm-hmm. But if we're requiring serialization, I certainly understand that the vast majority of people who don't use it to commit another crime, mm-hmm. we may not find it. And, we have plenty of laws that people break, and we don't find out that they break them because it hasn't created enough, that's not terribly uncommon, actually, that, we know that people might possess drugs in their home, and we're not going door to door looking for drugs. We don't find them unless they do something else with them. And so I think we have plenty of laws that only rise to the level of being caught when something else happens. But if we're requiring it, I think the vast majority of people would do what they needed to do to get the serial number. And if that did fall into the hands of someone, we would then be able to trace it because it had a serial number.
Well, I guess my thought here, Senator, would be blissful ignorance. I was amazed, and FFLs can speak to this. There was quite a thing about the 3-day waiting period. You would be surprised how many sporting-oriented Vermonters never knew it passed. They honestly didn't know. So if they didn't know that a 3-day waiting period, I can't go buy this gun now, are they really going to be cognizant of, I bought this, it was all legal, I made it, it was legal at the time I did it, it's been sitting in my safe. that's now illegal and I have to expend time and money. I understand it's inconvenience and for a non-gun owner, it's not an inconvenience to me. For a gun owner, it is. And by and large, we're law-abiding. I want to see tougher crime on guns. I think it will be meaningful, and I'd be interested in seeing a study as you referenced, but I don't want to take up committee time. I'm sorry.
Senator Booth.
So first of all, I just want to say I appreciate the testimony and especially that your organization is willing to look at parts of the bill that you can support, because I think that's how we get somewhere, is figuring out where the areas of disagreement and agreement are. So you referenced a number of times that under federal law, these would be legal. But we have other areas where states have more restrictive laws than the feds. And is that not so?
I usually see a prohibited person, a felon in possession. Federal law is 10 years, $15,000.
No,
a misdemeanor.
I'm saying, for instance, at the federal level, we don't have bans on certain things that we have bans on in the state. Like, for instance, high-capacity magazines, right? So we have made a decision as a state, as a legislature, to create certain areas where we're more restrictive than the feds. And this would be another area like that, should we choose to do it.
Mm-hmm.
So I'm not moved by the argument that they're legal and therefore we can't make them in a certain situation illegal, because the state has made the decision in certain areas to do that. So that's one thing. The other thing is, you say that this will only impact otherwise law-abiding citizens. And I think that your organization and others like it generally say that about any gun control measure that we pass, that it's going to have no effect. It's only going to hurt law-abiding citizens. And I don't believe that myself. And in terms of this bill, I think that there is an element in Vermont now working, you call them miscreants, I think that's a good word for them, gang members, people who are involved in the traffic of weapons from Vermont south and drugs from south north into Vermont. And we've had testimony to that effect. So if this can help trace some of those untraceable guns, then I think that's a good, and I think it would impact people who are not law-abiding citizens. So I take your point about the inconveniences involved with serializing weapons, but it seems to me that what we've been trying to do, step by step, methodically, is move into an area where you can't get a gun without a background check. And what you're talking about in terms of the PMFs is a way to get a gun that's not serialized, and without this bill would be possible without a background check. So you could be in possession of a functional gun that had evaded both the serialized scheme and the background scheme. So where I connect up with you again is when you're talking about the proposal to only penalize people if they use the gun in the commission of a crime. That's the approach we took on safe storage, right? That's the New Hampshire model, which is we didn't criminalize it in your home if it's not locked up. It's only if it's used to injure another person or seriously injure another person, and you commit that crime, then you can be charged. So it seems to me you're offering a similar approach here. It isn't, in this case, exactly where I would want to go, but that to me makes sense in the same way that it made sense in the New Hampshire model. So I'll just finish by saying, I think the general defenses that you've got here, I don't go along with, because it seems to me we do what you're talking about in other areas. But I do appreciate the idea that you've come up with a workable alternative to the bill. It's just not the one I would prefer.
For myself, and we'll come back to this at a later date, but I think the critical piece is to define properly what is a firearm in this category and what isn't a firearm. So you've given examples here of the unfinished receiver. This is a firearm, this isn't a firearm. I don't know we agree or disagree. But the goal here is to establish when it's a firearm, when it's not a firearm.
I guess just to
Before
summarize,
you pass the bill, we better know, that we're passing a bill that clearly defines when the unserialized weapon is a firearm and when it's not a firearm. So you can't leave much gray area for the courts to decide at some point.
I think the ATF has answered those questions, is when it
Well,
is
I
not
think
done.
we'll certainly, Eric, certainly capable of taking a look at the new ATF rules in light of the other states and where that's going. Also have outside information from other groups that I'm sure will come in as we go.
Well, I know your schedule is tight. I guess the only time we're gonna find one of these things, unserialized firearm, is when it's used in crime.
Okay.
And we should focus there, and if we do, we can have a domino effect. I think that's.
I realize the Second Amendment is different from my right to get on an airplane, but I do use that example. I think it's a good example.
It is poignant.
Of what happens.
I thank you very much. Really appreciate your time. Thank you.
Thank you. Now our problem is drunken airline passengers.
And as
I'm more of a problem now,
like taping them into their seats.
but I
Or airplane doors
digress
falling off,
there.
that seems to be a problem these days too.
I digress, and we're gonna move to the confirmation of several superior judges, but first we have some comments from a concerned citizen from Montpelier, Stephen Whitaker, who would like to comment on one of the superior judges.
Good morning, Stephen Whitaker from Montpelier. A difficult topic, but this is indeed where the rubber meets the road. I want to call to your attention with regard to former State's Attorney Rory Tebow, what I consider to be concerns that should be your concerns as well. I don't know what tools you have to investigate further in the compressed timeline of this confirmation process. But a few years ago, after working for several years to get the city council to address the lack of public restrooms in town, I did a protest art installation around town. All the flower barrels all over town and some of the hanging baskets up at 8 feet had installed nice, neat public toilet signs. There's a good slideshow of the photos if you care to. That was coincidentally the first day of the new police chief in town. And this story wraps around a police chief who later removed me from city council chambers for talking more than 2 minutes and threw me into a wall on camera. And shortly thereafter,
Okay, he's not up for.
no, he departed, right?
Yeah.
But my point is that too was a charge. I was charged with disorderly conduct, and shortly the new state's attorney looked at the videos and said, there's no crime here. There was no resisting arrest. There was no, and I was charged with disorderly conduct for the public toilet signs. I was charged with stalking one of the perpetrators who actually was destroying and ripping up the art installation. And Judge Griffin, who's a very fair-minded judge, threw that charge out, basically because he noted on the record that the only 2 times I photographed this person was when she was committing a crime. And yet, and the statute requires 3 instances to even meet a threshold of alleged stalking. But yet, this state's attorney, I believe in collusion with the Montpelier police, I would admit that I'm a pain in the neck to the Montpelier police because I'm not letting them live down their killing of Mark Johnson when they failed to connect the 2 dispatch records. He was he was suicidal, he was off his meds, he was hallucinating, and the city failed to connect the two records and shot him and killed him. And so I understand why Montpelier is annoyed with me, but that doesn't give a state's attorney the right to overcharge or falsely charge people. I was unable to walk along a section of State Street to eat at the ice cream place or at Willie Wan's, for most of a year. And to put that kind of impact on a person with no basis for the charge, and to not charge the merchants who destroyed the art installation, but to charge me with disorderly conduct is absolutely unethical. And I'm concerned that kind of deference to law enforcement would color judicial decisions as well. So that's the long and short of it. I'm happy to answer questions, but I've raised a thorny issue because it directly impacted me, and I'm still upset about it.
Understood. What we're going to do is give Mr. Tebow, or Judge Tebow, an opportunity to respond if he wishes. I was going to hold a vote on the other superior judges today, but Senator Sheen is still in the hospital with his partner, so I think in deference to him, we kind of hold off until next week so that he can vote on all.
I would hope he has an opportunity to review my testimony as well.
Yeah.
Wasn't he recusing from one?
He's recusing from Judge Battles.
So we could vote on that
That's
one.
what I was thinking.
We could vote on that, I guess, because he didn't want, because Judge Battles' representative was for
Yeah.
the case.
Yeah.
So yes, we could vote on the Judge Battles, I guess.
I left one
Well,
detail out.
yeah, go ahead, Steve.
That disorderly conduct charge after the unrelated or trumped up stalking charge was dismissed. The disorderly conduct charge did go to trial and was a hung jury. And then the new state's attorney said she saw no crime there.
So can you help me with the disorderly, the stalking charge? I'd like to understand.
One of the merchants.
Judge, State Attorney Tebow charged you with stalking based upon a police report from the Montpelier Police, is that correct?
Yeah, the Montpelier Police, I'll use the word colluded with one particular merchant who I had photographed and reported to the health department because she was repeatedly bringing her dog into Capitol grounds. The dog was nosing into the food, jumping for treats, and it just totally inappropriate and illegal in a restaurant setting. And I took a picture of that and I reported it to the health department after first giving the merchant, the coffee shop owner, a chance to remedy it.
The second time you photographed.
When she was tearing up my art installations.
And so the Montpelier Police sent those to the state attorney's
Correct.
office. State attorney decided to prosecute, the judge threw it out.
Even though there weren't 3 instances, I believe the stalking requires 3 instances, which is the base.
I don't have that right in front.
And I'm not a lawyer either, so I believe
Eric is.
there is a good motion that Avi Springer filed that resulted in that dismissal, which lays out the component elements of a valid.
But I just wanted to be clear on the stalking charge, because that's a fairly serious offense. Somebody's convicted of it, there's serious consequences, so.
And this was entirely fabricated around me doing public advocacy around public restrooms.
Disorderly conduct is kind of a,
Catch-all.
catch-all, and I can understand that. If you get this report from the police, state's attorneys are judging their decision based on the police reports.
And they didn't consider destroying
Right.
my property and my art installation.
Understood. The good news is that a judge threw it out.
Yes.
Did you have a question, Tony?
I did not. I was just amused by our circle back to disorderly conduct. We've talked about that so much in this committee.
Yeah, we do. There's a lot of that going on in this committee.
Is there a stocking question?
Yes, stocking.
And I missed the specifics of the question. Sorry, I'm looking at the definition right now. 2 or more acts over a period of time, was that the question?
Yeah, it's 2 or more acts, not 3. Okay,
Right.
that was the question, so it's 2. But at any rate,
And photographing someone, from a distance, I don't, you
I'm
know,
glad they were, dismissed. We've had a lot of stalking incidences that rose much higher than that. We had one in Bennington where the guy used a plane to stalk somebody in Glens Falls, New York.
but to even lump me in with folks that are threatening the speaker and all, it's just a gross injustice to me for trying to get the health department laws enforced.
What we're gonna do is give, Judge Tebow the opportunity to respond to your concerns, which is what we always do, and we will not vote until after we've heard from him and now that we've heard from you. And if anything else comes up, feel free to let us know.
But my concern and ask you to look at is how many other people is this happening to? How many people are being overcharged for punitive or the wrong reasons?
I think statewide, a lot of people are overcharged, and that's the way they get the plea deals.
And I don't
I
expect,
think you would
yes.
find that that's common among state's attorneys.
And I refused all plea
And the
deals.
police use overcharging in a number of areas. Is it attempted murder or is it, what is the proper charge in this particular one, whatever case it might be. I think you'll find there's accusation of overcharging. That's why we have a system that tries to get to the fairness. But yeah, there's overcharging everywhere. We know that. It's part of the plea bargaining deal. We've tried to get consistency. You'll find it's more likely if you shoplift that you're going to, even if you end up in diversion, you're gonna get charged in Bennington County, but in Chittenden County, you're probably not gonna get charged. You're probably gonna go direct to child services.
And
So, I mean, there's differences.
I understand. In closing, I'd ask you to give some thought to whether or not our expungement provisions are adequate, because this could come back to haunt me year after year after year.
We did something about expunging non-convictions where they were just charges.
Would that even be on your record if there was just a charge?
Yes.
And it's also still in the Valcor's database, subject to
That's
release
still
there.
we did something about that, or maybe it was in the bill that the governor decided not to sign and seal, but we can check it. I think Michelle did that.
Right.
We need to check with Michelle on that, but I think that came up a couple of years ago and we tried to address it in a bill. I don't know that the bill ever passed, but it is a problem for people who've been charged, and the charge still hangs out there, even though it's been dismissed.
Mm-hmm.
It's still on the record.
I mean, back when Senator Sorokin's wife
Right.
was in the Senate, and she was also on the 911 board. The 911 board tried to meet illegally, and I entered the meeting and was arrested by the same Montpelier Police Department. And that's still on my charge, on my rap sheet, but
All kinds of patterns here.
no, never convicted of a crime. There's patterns of police abuse, yes, including the chief lying about numerous things. I won't go into it here.
Thank you very much.
Thank you.
Appreciate it. So yes, we will check, make a note the ceiling bill is over in the House. They're taking it up. And a note to Michelle about the issue of records of charging and how to get those expunged as well. Because they do hang out there forever.
That seems really problematic. If someone is ultimately found innocent or the charges are dismissed, that should not continue to harm them.
I'm just ask George Bush. The drunken charge over in Maine, remember?
I don't.
Oh, yeah.
Well,
It was like the day before the, New Hampshire,
yeah, I think it was an Hampshire primary.
it got released that he had had a DUI and, they thought for a while it would derail his whole campaign, but. he
Which
powered-
Bush? Junior?
Oh,
or-
Junior.
Okay.
Yeah.
I was gonna say, because if it was senior, before my time.
I'm sure he had, Junior
Had
had a glass of
DUI
wine.
in Maine when he was a teenager. I think he was a teenager.
No, I think he was in,
23?
yeah,
No, it was young.
yeah.
Interesting.
DUI in Maine charge, and I believe it was reduced or
Yeah,
not processed.
yeah, that's where,
The charge was still out there.
Alberto Gonzalez got that charge dropped.
Interesting. Huh. You learn something new every day.
Well, that was the issue, I think, that led us to look, when we were doing expungements, to charges, because they're still there. Stevens just reminded.
Yeah. We should do something about that.
Well, we'll have an opportunity, I
Excellent.
hope, if the House passes the bill. Anyway, so back to the judges. Is there a motion to report favorably, Judge Adams?
So moved.
Thank you. Is there any discussion? Well, we have to call the roll, because it's a confirmation of the judge, so this is your first opportunity, Ben.
For a moment.
To call the roll, and we know that Senator is gonna recuse himself,
So, this is the confirmation of that was the Superior Judge, Senator Bruce,
Yes,
Senator Norris,
Yes.
Senator Kowalski,
Yes.
Senator Sheehan will recuse himself, and Senator Sears.
Yes. Who would like to report on Judge
I'm happy to. I
That'd be
made the
great.
motion. I'd be happy
Thank
to.
you. Tanya will take up the name and, that would be great. And we'll take up the other judges when Senator Sheen is here next week. So, fit in, and also hear from Rory if he wants to comment on Mr. Whitaker's comments.
We should have some time on Friday, if that works.
That Friday is our best day,
I know, that-
Judge Day. So we're gonna take, we're ahead of game. We're gonna take a break till 10:15.